नमस्कार फ्रेंड, आप सभी का एक बार फिर से स्वागत है और आशा है, उम्मीद करते हैं कि आप सभी लोग अच्छी तरह होंगे। फ्रेंड्स, यूको बैंक के एक डिसमिस्ड एम्प्लॉय का एक केस है जो सुप्रीम कोर्ट में एक अच्छा डिसीजन उनके फेवर में हुआ। सुप्रीम कोर्ट रिजेक्ट्स यूको बैंक्स प्ली दैट एम्प्लॉयज डिसमिस्ड फॉर मिसकंडक्ट was not entitled to pension despite 10 years service. The Supreme Court rejected UCO Bank's plea that a bank employee who has completed over 10 years of service was not entitled to superannuation benefits when he was dismissed on ground of misconduct. The bench comprising Justice Abhay Yas Oka and Ujjal Bhuyan upheld the Punjab and Haryana High Court decision directing the appellant UCO Bank to grant pensionary benefits to the respondent employees removed from service for misconduct after completing 10 plus years in the service. In 1998, the respondent was charged with assaulting a bank officer and was dismissed following an inquiry in 1999. In 2000, the appellate authority modified the penalty to removal with terminal benefits, a decision that went unchallenged by the appellant bank and attained finality. In 2004, the Labour Court reduced the penalty to stoppage of increments and ordered reinstatement with 75% WAC wages. However, in 2009, the High Court set aside the Labour Court award, reinstating the removal with terminal benefits. Subsequently, in 2010, the respondent opted for a pension under the bipartite settlement. The High Court later directed the bank to grant pension benefits, relying on the Supreme Court's ruling in Bank of Baroda versus S.K. Cool 2014. In S.K. Cool's judgment, the court held that if the bank employees has completed the minimum pensionable years of service, 10 plus years, he would be entitled to the pensionary benefits even if dismissed on the account of misconduct. The appellant opposed the grant of pensionary benefits to the respondent, citing Regulation 22 of UCO Bank Pension Regulations, which denies pension for the removed employees. However, the respondent employees referred to the bipartite settlement agreement arrived between the Indian Bank Association and the bank's workmen union on 19th October 1966. This settlement was arrived under Section 2P and Section 18(1) of the Industrial Dispute Act, read with Rule 58 of the Industrial Dispute Rules 57. It has a statutory backing and is binding on the parties. Clause 6B of the bipartite agreement states that an employee who is found guilty of gross misconduct may be removed from service but would be provided with the superannuation benefits which would otherwise be due to him. Issue. Because of the contradictory stand of both the parties, the question appeared before the court was whether the Regulation 22 override the bipartite settlement, which had statutory force under the Industrial Dispute Act. Decision. Answering in negative, the judgment authored by Justice Vian relying on the case of S.K. Cool harmonized both the provisions and observed that Regulation 22 cannot override the bipartite settlement, which has statutory force under the Industrial Dispute Act. The court rejected the appellant argument regarding the non-application of the S.K. Cool's judgment in the present case. The appellant argued that in S.K. Cool judgment applies only where the employees opted for pension before removal. The decision in S.K. Cool was rendered in a different factual context. The employee in the said case had opted for pension before the penalty of removal from service was imposed on him. In the present case, respondent never opted for pension. Therefore, SK Cool is clearly distinguishable in so far facts and circumstances of the present case is concerned, the court observed. Both the learned single judge and the division bench had followed the aforesaid decision of this court. Learned single judge noted that the respondent had submitted his option for pension on 5th October 2010. Learned single judge also held that the objection of the appellant to the claim of pension by the respondent was without any basis in as much as the appellate authorities had specifically held that respondent would be entitled to receive terminal benefits for the period of service he had rendered. This order of the appellate authority has attained finality. Therefore, it was held that the respondent was entitled to receive pension in view of the order passed by the appellate authority. This view of the learned single judge has been endorsed by the division bench in the impugned judgment. The decision in SK Cool is binding on us. Therefore, we do not find any compelling reason to interfere with the concurrent findings of the learned single judge and the division bench while exercising our jurisdiction under Article 136 of the Constitution of India. The court observed. In terms of the aforesaid, the court dismissed the appeal. Case title UCO Bank and others versus Vijay Kumar Handa. Thank you, friends. Namaste.